Hi, everyone. I am Janice Gregerson. I'm with the law firm Venable, based out of our DC office. I work in the education practice, and all we do, many of you have probably seen my colleagues Karen Pass and Megan Mann, and all we do is really education and independent schools all day, every day. So we're living and breathing in your world consistently, and we love it. I am particularly so happy to be here today because you've given me relief, periodic relief, from the cherry blossom tourists in DC, which gives me immeasurable joy. And if any of you were cherry blossom tourists, I apologize for the scowl that you probably received from my car. But thank you. And during this session, we're going to go over a legal roadmap. I like for this to be as beneficial for you as it can be. So if you have questions during the session or thoughts you want to share or anything like that, feel free to jump in. You don't need to wait until the end. I don't want anybody to have a thought and then suddenly lose it, because I know that happens to me all the time. So we'll dive right in here. Did I do that right? Oh, I didn't. Now I did. Okay, a little agenda for our session today. We're going to go over some overall considerations that I think are equally applicable to any instance that you're going to have arise in an independent school, and particularly for you as the admissions officers, that you're just going to have in the back of your mind. These are going to be your guiding considerations. We'll spend a moment on Operation Varsity Blues, just because I cannot help myself to not mention it. It's like the $15 million elephant in the room. Like, we have to talk about it. We'll move into the non-discrimination considerations, and particularly the laws that are applicable in the independent school context in that regard. We'll spend some time there, because that's really where the most liability challenges that I see arise, because it's pretty easy to get tripped up. We'll move into vetting and some considerations that you're going to want to have in mind while you're vetting, and then take a little pop-off at your enrollment contract, a really light primer. But, little spoiler alert, session in here after here is the enrollment contract, and it's also me. So there you go. All right, your overall considerations applicable at all times, regardless of what's happening. The safety and security of your students is absolutely your first priority, and for you guys, it's also going to be your visitors, your admittees, everybody. You do have a legal duty of care to students and newly admitted people who are visiting while they're in your care, and you just need to make sure that you're mindful of that and letting that guide the decisions you make. I call this the zero risk myth. There is no such situation where you're going to have no liability at all whatsoever. It just doesn't exist. Any lawyer that tells you that is lying. Apologies to my lawyer colleagues who say that, but they're lying. Which means you're always going to want to perform a risk-benefit analysis. You may ultimately decide, I'm going to ask some more marginal questions in my admissions application, because it's worth the benefit that we get out of it. Could we possibly get sued? Is it black letter law? Maybe, but you're making that conscious decision that it's worth the risk. Be willing to learn. Operation Varsity Blues, obviously, making an excellent point of that, but people make mistakes. You're human. You're schools. Things happen. Things go wrong. Just be willing to learn and grow from that experience. So culture. Karen says culture is king. Megan says culture is queen. I got tired of the gender dispute between the two of them, and so I say culture. It's going to, culture is driving everything in your community, just like in real estate, property drives everything that you're going to consider. Always do a gut check. 9 times out of 10, if something feels wrong, it's making you uncomfortable, it's giving you a little agita, don't do it, right? And be consistent. This is really important, in particular for you guys, confirming that your policies and practices are equally reflected across all your documentation, because if your enrollment contract says one thing about your student policies, but your student handbook says another, or your enrollment contract says we do this and your student handbook doesn't mention it at all, that's going to create a problem and a really difficult challenge for me if maybe you get sued and then I have to litigate that contract. So super important. Okay, Operation Varsity Blues. I love this picture of Lori Loughlin signing autographs on the way into her plea hearing, her indictment hearing. I aspire to one day care that little about going to jail that I'm actually willing to stop, wear amazing glasses, get a blowout, and sign autographs on my way in. It's amazing. Another quick aside, because I also can't let this go. It really bugs me that they're calling it Operation Varsity Blues. I have an unhealthy knowledge of teen movies. And Varsity Blues has absolutely nothing to do with college admissions whatsoever. It's a tale as old as time, small town Texas. The star football quarterback gets injured. Oh my God, what are we gonna do? Oh, magically the bookish backup is able to just easily step into his place and everything's fine. But nothing to do with college admissions. Had DOJ called me and said, what do you think we should call this? I would have said stealing Harvard right away. Criminal element and college admissions in one movie. So if anybody knows anyone at DOJ, just slide in that pointer right there. They need to do better next time. But seriously, it is good to keep an eye on what's going on in higher ed, because it inevitably, in some form, in some way, shape or another, trickles down to independent schools, particularly those of you that are working in schools that are upper schools or have upper school divisions. So why do we care about Operation Varsity Blues? I think the initial reaction when the indictments started to come out was, duh, wealthy parents pay extra money to get their kids into places they don't deserve to go. Duh, what's the point? Yes, true, I know that doesn't happen at any of your schools. The well-placed, the well-timed donation never happens at your schools. But the reason Operation Varsity Blues is such a problem, is attracting so much attention, is that it is a bribery scheme. Literally implicating coaches, admissions officers, no one in here, accepting millions to get students into colleges that they had no place being in. Justice Department's largest college admissions investigation, I actually don't think they've ever done one before at that level, so I don't know why they're calling it their largest, but they are. But it's getting attention at the federal level because of a statute called RICO. RICO grew out of efforts to combat organized crime. So they're literally treating the actions of the parents, admissions officers, the one college prep guy who ran the charity organization where everybody could funnel their money through, like organized crime, like members of the mob. So they're being charged with racketeering, and they're also being charged with other crimes in relation to that, right? Wire fraud, mail fraud, all those horrible, awful things. Lesson for independent schools, I think, don't take bribes is probably a good place to start. I mean, that's a baseline I think we can all agree on. But I think also really evaluating and being aware of what's coming through your door. So some of the allegations in this are like Photoshop pictures of Lori Loughlin's kids rowing crew. And it's like, you can tell, right, when the line is right, that's not her body, you know? Evaluate the application that's coming through your door and be like, is there something off about this? But, you know, we're not gonna spend too much time on that because no one's taking bribes in this room. All right, the law, non-discrimination. We're gonna focus on the federal level, and we'll go down to the state level as well. Be aware that some of your localities will also have local laws as well that may or may not apply to you. So when I'm talking about a local law, we're talking about a local human rights code, for example. So, you know, your county might have a human rights code, and the way that they write the human rights code could include students at independent schools. So just be aware of that, that's out there. Generally speaking, your federal law is gonna set the baseline, the minimum of what you cannot do. State law is gonna expand on that, and a local law will expand on that even further. All I know that we're going to talk about legal obligations today, and I know that your NYSAIS membership requires non-discrimination compliance as well, which is important to follow. But we also want to be aware of the possible liability that could arise under federal and state law in here. Perhaps some of you are thinking, duh, Janice, we can't discriminate. We know that. We get that. And it's true, right? It's on some level, we're all like, all right, this is an obvious point. But it's not just the decision that we're thinking about in admissions, it's the whole process. What questions are you asking? Is your policy being applied consistently? Do you have a facially neutral policy on admissions? For example, documents that need to be provided, interviews that need to be conducted, et cetera, that inadvertently has a discriminatory effect, right? So inadvertently, members of a certain protected class aren't able to provide that, aren't able to sit for that additional interview, whatever it may be. That's what we call a disparate impact discrimination claim, which differs from a intentional discrimination claim, where that's saying you didn't admit my son or daughter because, for example, he and she is African American, right? So there's two pieces of that to watch out for when we're talking about discrimination. Largely the distinction on the federal level is on who receives federal funds. So there's a slew of statutes that apply to schools that receive federal funds. FERPA, Section 504 of the Rehab Act, the ones I listed up here, Title VI, Title IX, IDEA, trigger receipt of federal funds and then in what manner you receive them. I'm not going to spend time on those today because by and large, most of you are not receiving federal funds. If you are in some way, shape, or form, know that that's a red flag and that that's something that you're going to need to investigate and follow up with to make sure that you're in full compliance. But what we are going to spend time on today are 3 federal statutes and then the State Human Rights Act that apply regardless of whether or not you have federal funds at all. So, race discrimination. This is Section 1981. Sorry. And what Section 1981 basically says is that there can be no discrimination on the basis of race in the making or forming of a contract, or making or enforcement of a contract, excuse me. So what does that mean for you guys? Your enrollment contracts. The offer of admission, the offer of an enrollment contract, the terms of an enrollment contract. Section 1981 has, in case law, specifically been held to apply to independent schools, so there's no question here that it certainly applies to you. Originally was, enacted to combat race discrimination against African Americans coming out of slavery, but eventually has been expanded to cover other, what they call identifiable protected classes that could be subject to discrimination based on ancestry or ethnic origin, so something that's kind of grown out of race, perhaps related to race. It's not going to cover things like sex. It's not going to cover gender identity. That's not covered on the federal level at all. But it is going to cover anything that's race or touches on race. Unrelated, I litigated this issue hotly and heavily when I was litigating before I joined Karen and worked for independent schools, that a Section 1981 claim should not apply to a national origin allegation. I probably shouldn't admit this openly. I lost that argument. I still cry about it today, but it's true. It's not how the statute was written, but that's how it's being interpreted, so know that as well, particularly if you have an international population. Did I see it? No. Okay. Diving into 1981. So, all right, no race discrimination. Great, we get that. But maybe some of you are thinking, well, we do consider race in admissions. Well, obviously, we're trying to increase the diversity of our overall student body as a whole. Yes, you are. Any consideration of race, particularly under a federal statute, is going to be held to the highest level of review, which is strict scrutiny. And that means, basically, that you have to show a compelling interest in the consideration of race, and that your practices have to be narrowly tailored to ensure that you are achieving that interest. So, compelling interest, Supreme Court has long said increasing diversity in a student body is a compelling interest. Most of these cases are coming out of the higher ed context. There's not a lot of case law in the independent school context. And courts are noting this doesn't mean you need to consider alternatives to race. So what would be some alternatives to race? Perhaps geography, where they're coming from geographically, financial means and ability, nationality, which could be tied back to race. But you don't have to exhaust every alternative to diversifying your student population. However, while there's a lot of case law for higher ed, not so much for independent schools. And it has been suggested, or indicated at least, that building diversity is not as compelling of an interest in the independent school context. And when I say has been suggested, I mean by the courts, that's not widely accepted in the broader legal community. Personally, were we to have to defend a policy, an admissions policy that considers race in that context, that compelling interest of increasing diversity, the argument that you're going to want to make, or that you're going to want to have in the back of your mind is, we're preparing these students to go on to college, where they certainly consider race as being that compelling interest there, and to go out and work out in the broader society. We're not just educating them on a lower level of here's your basic arithmetic, your math, your et cetera, check the boxes and go. We're developing the whole person. And developing the whole person means developing the whole person to be able to interact with different people and different cultures and different ideas. So that's one thing that's just kind of not a red flag, maybe a little yellow flag, a little warning out there that it's not getting as much treatment for K-12 as it is for higher ed. When we're also developing our race consideration policy for 1981, you need to have a clearly articulated reason, and this seems silly, right, as I'm saying it, a clearly articulated reason for why you need to have that diversity policy. As it's coming out of my mouth, I'm like, this is nonsense. Everybody knows why we want a diverse student population, but this is what the courts are saying that we need to do. Some of those diversity justifications, benefits to the education environment, preparing students to live in a diverse working world, breaking down stereotypes, excellent one, invigorating classroom discussion, promotion of cross-racial understanding. All of these are really, really important. But what you also have to do, in addition to the compelling interest, is limit your consideration of race so that it is tailored to achieve those stated goals, that articulated diversity justification. You have to do an individualized assessment of each student. We don't want quotas, we don't want caps, we don't want numerical numbers. Diversity in your classroom is not a number, it's not a percentage. In particular, for those schools in here that have a lot of applicants, first of all, good for you, that's amazing. Big clap. But if you do, you are one of those schools that just gets inundated and inundated and inundated with applications, consider how you're weeding out. How are you doing that initial blush? And think back to our disparate impact discussion. It's not so much a discussion, I was telling you about it. But think back to disparate impact. Is our policy facially neutral? Okay, we weed out anyone that doesn't come from these geographic areas, maybe, right? We're gonna weed out anyone that's living too far away because, realistically, if we offer them admission, they're not gonna come here anyway because it's gonna be too long of a commute. Just throwing that out as an example. Well, could the disparate impact of that initial weeding out be that you're weeding out students of color? Could that be? So think about how you do that initial assessment, how you do that initial tease through. And think about how you do it at every level, every stage of your admissions process. What are the criteria you're applying to move kids on from level 1 to level 2 to here's your acceptance letter? You have to routinely tweak and review these efforts. Like my dad says, preventative maintenance is key. He still takes his car in to get his oil changed every 3,000 miles on the dot. Sometimes it's at 2,500. And even though He's still at Pentagon with a fantastic job and very busy man. He finds time to call me to remind me to do the same. I don't know how he knows the mileage in my car. I'm a little unnerved by that, but maybe it's just a sixth dad sense or something. But that's what I mean, right? It's preventative maintenance. Reassess your criteria, reassess how you're reviewing applications and say, is this still narrowly tailored to meet our diversity justification? Is it working? Are we inadvertently excluding students of color, students of different gender identities, students of different financial means that we shouldn't be excluding? Sorry. And finally, pre-admission inquiry about race. It's not prohibited. Make it voluntary, because it's going to make your job easier on the back end if you do have to defend yourself against a race discrimination claim. If you didn't know, you couldn't discriminate. By the way, I'm going to contradict myself later in this session when I talk about the knowledge of that. I'm going to preface that out, guys. So it's not for race discrimination, it's not only a threat of litigation, it's also Revenue Procedure 7550. Why is that important? Why should you care? Because independent schools that discriminate on the basis of race, color, or national origin in admissions, hiring, or any other term of condition of employment for that matter, could lose their nonprofit status from the IRS. That's a biggie. We don't want to lose our nonprofit status. How do we avoid that? Not only do we have a racial and non-discrimination policy, but we also actually operate consistently with that policy. So it's not sufficient to just have the lovely statement on your materials that says you don't discriminate. You actually have to not discriminate too. So what does that really mean? I know, it's like obvious, but people forget. So what does that mean? Non-discrimination policy in the charters or bylaws is going to be important for your boards. In your brochures or catalogs about admissions, written advertising that you're sending to any prospective students, it needs to be in there as well. And there's also a publication requirement, and I think it's like 12-point font, Times New Roman, in the newspaper, circulated to the geographical community that you're drawing from, something like that. Fortunately for you, I understand that NYSAIS is one of the independent school associations that can bundle and does all your non-discrimination publication for you. So yay, NYSAIS. Big hand for NYSAIS. Not everybody does that, so it's important. But there is going to be a little bit of race discrimination in considering it. What about scholarships or financial aid that's designed to attract students that might not have the financial means to attend the school? That's fine. That's fine, so long as it's promoting the non-discrimination policy, again, that narrowly tailored, compelling interest. Reverse discrimination. This is also a topic that's getting attention lately. The Trump administration has signaled an interest in, I guess, investigating, evaluating, assessing reverse discrimination admissions practices that are focusing on affirmative action. When I say signaling of the interest, I mean tried to hire attorneys, perhaps successfully did so, attorneys that would be able to challenge affirmative action programs. It hasn't gone anywhere further since that, but that's also one thing that we're going to need to keep an eye out for over the next I'm not going to put a time limit on it. That's just something that we're just going to need to keep an eye out for if that changes at any point in the future. Reverse discrimination, what is it? It's a challenging concept. It's a claim that favoring a policy that favors a minority group is actually discriminating against a majority group. In reality, any reverse discrimination claim, like in the employment context, for example, if someone is saying, well, it's always, sorry for the white men in the audience, it's always the white male. Oh, they discriminated against me because they wanted to hire that younger female. Reverse discrimination. You actually have to show a higher burden, a demonstrably higher burden to demonstrate, quote, an intent to discriminate against, a majority race. So it's a very difficult burden to meet. So what that means for you, your admissions policy that favors racial minority groups is not going to be considered discriminatory in the sense that it's reverse discrimination, because it's promoting the establishment and the maintenance of a diverse student body, and it's promoting that policy. So you're good for now. Yes?
Is there a case out of Harvard right now that the Supreme Court about harm reduction, or where are we with that particular case?
Yeah, so there is a challenge being made to that out of Harvard. I believe the actual claim is that Harvard favors students from Asian countries.
They're discriminating against Asian.
Right. It remains to be seen how that one's going to shake out. You know, you're asserting discrimination against a protected class. You're taking in a lot of factors there. What applicant pool are they getting? You know, you're not really able to control Harvard's applicant pool. Whoever applies, applies, right? They also have very strict screening criteria. By the way, full disclosure, I did not get into Harvard, didn't even apply. Couldn't deal with that rejection. But right, high SATs, high grades, a lot of extracurriculars, right? The star student. So I'm not sure, I don't want to gamble in the case law because I've been wrong before when I do, but that's going to be an interesting one to shake out and see how that one actually comes to play out. I have an opinion, I'll keep it to myself for now. Any other questions on the race discrimination front, national origin, before we move on to disability? But good question. Okay, disability, we're talking about Title III of the ADA, applies to independent schools, right? So before in the earlier slides, the individuals with disabilities in Education Act, IDEA, and Section 504 of Rehab don't apply to you. I want you to know that because I've seen emails from parents to admissions officers, just like you, saying, I'm asserting my Section 504 right, and I want my advocate present when we meet. They don't have a Section 504 right, and you're certainly not allowing an advocate present while you meet. Just to throw that out there, just good pointer. Why do I asterisk independent schools? There is a religious exemption. Not really sure why this applies to disability claims, but we'll go with it. It's just how the law is written. The religious exemption is determined by how the school operates and who it is controlled by. So what that means, basically, in theory, you can discriminate on the basis of disability if you are under that religious exemption. You're controlled by a religious organization. You can decline to provide reasonable accommodation if you are controlled by that religious organization. Any religious schools that are considering asserting that exemption should tread with caution. One, consider, have you actually asserted that exemption in the past? If you haven't, it's going to be a red flag if you do in the future. But also that really requires undertaking an assessment of how your school is actually controlled. I went to a high school that had a convent on campus. We were not controlled by the sisters, despite their best efforts. not for not trying, but we would not have been eligible for that religious exemption, even though, right, we had that physical presence of them on campus. So what does Title III tell you that you can't do? Can't discriminate, obviously, again, but also requires you to make reasonable accommodations for disabled individuals, so long as there's no undue hardship to you, the school, so long as there's no direct threat of harm to the individual or others, and so long as it doesn't require a fundamental alteration of your program. What we're doing in the reasonable accommodation process is leveling the playing field, not giving someone a leg up, right? We're helping someone meet the standards that we would expect of an otherwise non-disabled student. We're going to tease out more in a couple minutes what really is meant by reasonable accommodation and what your obligations actually are. A little point to note too, the inquiry changes under all of the disability discrimination context if you are a school that caters to students with learning style differences. So then the inquiry is completely different because you're not excluding on the basis of that ground. You're actually trying to create a population that you can serve in the best way. Who is covered? A lot, and actually I should have said this at the beginning, nearly everyone is covered by some form of anti-discrimination statute. I would be hard pressed to find someone who's not. Particularly with disability though, who's covered? Someone who actually has a condition that substantially limits a major life activity or function, which we'll tease out. Someone who has a record of an impairment, maybe they had it at one time, they don't have it anymore, or someone who's regarded as having an impairment. So they don't actually, but you just treat them like they do. For you guys, I think the one that you'll most often encounter is the actual physical or mental condition, not necessarily so the record or the regarded as. Okay, what's a disability under the ADA? Really, 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 really broad. To go back to the previous slide, a physical or mental condition that substantially limits a major life activity or a major life function. Activities, standing, walking, reading, talking, lifting, bending, pulling, pushing. Major life function, all of your body systems. Neurological, endocrine, circulatory. I didn't do well in biology, that's why I can only name 3 systems. Again, sorry to the nuns. But these are the impairments that you'll probably most often encounter in the admissions context. And these are going to be considered automatically, really no questions asked, covered under the ADA. Sorry, just checking my time. Visual, speech, hearing, learning, ADHD. Everybody has ADHD a bit, I think now. Diabetes, autism, epilepsy, depression. I think everybody has a little depression and anxiety now. What's that? Major life function, the brain, nervous. I got another one. Bipolar, learning disabilities, learning style differences. When we're looking at learning style differences, the question that's being asked is you're comparing the difficulty and the time and the effort that student has to put in to get to the same level that a student who doesn't have those differences. So the limit on the major life activity is the time and effort that they have to put in. Basically, everyone on some form is going to be covered under this. So this begs the question. Yes? Yes, actually, so the question was, are eating disorders covered under the ADA? I would yes with an asterisk that one. If we're considering the eating disorder as stemming from perhaps depression, bipolar, anxiety, something like that, it's certainly been affiliated with mental health. That's certainly going to be considered something that's covered because it's substantially limiting your major life, your neurological function. Yeah, absolutely. Yeah. I am so glad you asked about food allergies because I feel like I've spent the last 6 months of my life dealing with food allergies because I have. But yes, the food allergy question actually is, the question was, are food allergies covered? Yes, if severe. So the courts do consider that there is going to be some level of food allergen on some level. But where we get to covered if severe is if they are in fact substantially limiting, right? There's a threat of death from ingestion or being around the food allergy, or the contaminant, you know what I mean? Any other hands? Food allergies, eating disorders, for sure. So what does this mean for you in the admissions context? Well, there's certain conditions that you might want to know someone has before you make a decision to admit. Why? Because you don't know if you're A, going to be able to accommodate that person if you do admit them, or B, if they're actually going to be successful in your program. So this is where it gets challenging for you guys. And this is probably the most challenging part. The ADA compliance manual says that you cannot make unnecessary inquiries into the existence of a disability in the admissions process. Unnecessary being the key word. You can seek information that will inform you whether an applicant can participate in the essential functions of your programming. So not everything. Will they be able to go to class? Not necessarily will they be able to make all A's. Will they be able to go to class, participate in class, do homework? I'm not sure that I would call participation in extracurricular activities an essential function, but will they be able to be a part of your community? Not necessarily a big man on campus, but will they be able to participate? And you can make inquiries as to whether the person is entitled to a reasonable accommodation. Ultimately, if you do choose to make an inquiry into disability in the admissions process, your ultimate decision has to be disability blind. You cannot say, weighing two applicants equally, they both match up on paper, but we know this one has ADHD, and we're concerned we can't accommodate it. By the way, most likely you're going to be able to. But this kid doesn't have any condition. If you make the decision to admit this kid because this one has ADHD, you've engaged in disability discrimination. And how is that going to be proven? Because you knew about the disability. This is where I contradict myself, right? I said, it's fine to ask about a protected class. Well, now we're making it a little harder. So there are improper and proper inquiries into disability. Improper, does your child have an IEP? Why is that improper? Well, it's not really necessary for you to know whether a student has an IEP to know whether or not they'll be able to participate in your program. IEP, like it is. Individualized assessment, clearly a plan was put in place for that kid somewhere else. But what you can ask is, will your child need assistance or modification to the school's program and services in order to fully participate? Only ask this question, by the way, if you're asking all applicants. This can't be a question that you use to screen out, and it can't be a question that you only ask if you suspect that something's going on there. Now, the reality is, do you actually need to ask that question? It raises yellow flags for you. I'm not going to say red, but it's going to raise yellow flags for you. Because if the answer to that question is yes, and you decide not to admit, parents could make a claim against you that it was on the basis of disability. Consider whether you can wait to ask that question until after the offer of enrollment has been made. This is where we get into our risk benefit. What do you need to know when? In the employment context, we handle it the same way in hiring. What do you need to know when? We don't ask about a criminal conviction until after the conditional offer of employment, not likening disabilities to criminal convictions. But you're also not going to ask about whether someone needs a reasonable accommodation until after they've actually walked through your door. So, another way to maybe get at the information that you need without exposing yourself to potential liability is a general question. Is there anything else the school should know to make sure that your child is able to participate? Or cut it off there. Is there anything else you would like the school to know about your child? Period. End of sentence. Maybe parents will say it, maybe they won't. Still doesn't eliminate the possibility that the parents that do have just disclosed information to you. But at the end of the day, no one's going to discriminate in here. And we're going to make a disability blind decision. Did I see a hand? Yes. So the question is the school required to follow an IEP for the entrance exam? And actually, what was your second question? Because that's a great segue into my next slide.
There are so many parents complaining about IEPs because they are trying to get their child into school without the IEP. Does that become the school's liability?
Yeah. So that's a fantastic question. So it is a really fun one, and it's actually, I feel like we're on the same wavelength because it's such a great transition into my next slide of reasonable accommodation. So the question was, what if the family doesn't disclose the IEP? Are we required to follow the IEP at the admissions process? Does it create liability if we didn't know about the IEP? Potentially, yes. So this is where we're going to do our deep-ish dive into reasonable accommodation. Reasonable accommodation is an affirmative obligation on your part. Not passive, you can't sit back and relax on it. It's affirmative obligation. You have to provide a reasonable accommodation to allow a student to participate in your program, which would include admissions testing. Does that mean you need to follow the IEP? Not necessarily, because providing a reasonable accommodation requires you not to do what someone else says, but to do an individualized assessment. Now, what's important to do once the reasonable accommodation process is triggered is get medical documentation. Ask, what does the student need? Is it extra time, time and a half? Is it double time? Do they need a laptop? Do they need a calculator? What is it? And get that assessment from a medical doctor, not mom or dad's friend. That's a doctor that lives down the road. By the way, doctor parents are just as bad as lawyer parents, if not worse. But all it requires is that interactive process, right? That you're having that dialogue with mom and dad and figuring out what accommodation can we provide. It is amazingly easy to trigger the requirement to provide a reasonable accommodation. All they have to say is, my kid needs a laptop because it's hard to write. Well, okay, that doesn't really say much to you, but all they've said is, my kid needs something because of some sort of condition, hard to write. And then it's our obligation to dig down further into that and say, okay, what does that actually mean? Is this actually a disability? Is this actually a condition that substantially limits a major life function? Or is it just your kid's hand gets cramped when he writes for a long time, which, like, hi, duh, my hand gets cramped after 5 minutes. But that's all it is triggering that dialogue, that responsibility on your part to seek information. Now, yes?
One question. You said in your previous slide that it's improper to ask for an IEP. Can schools ask for a psych evaluation? The IEP part is it's individualized, but like. Yeah.
When would you ask for that? So the question was, can schools ask for a psych evaluation?
I'm a secondary school counselor, so it's more, there are schools that maybe my students are applying to.
Yeah.
Sometimes, like, some of them ask at the end after they've been admitted.
Yeah.
Some of them, but I do think, at least from what parents tell me, that some schools ask. If there is one, would you provide it? The language and wording can change, but.
So yes, some schools do. Is it advisable to ask for a psych, if on an application at the first blush, is there a psycho-ed evaluation? Don't ask it at the first blush. Ask it, if you're going to ask it after the conditional offer of admission has been made, or the offer of admission has been made, or if during the other point to this, because a psycho, that evaluation is very important. The other point to this is, if in the context of doing your vetting, you call the sending school, and the sending school says some things to you that raise some red flags, violent behavior. They had concerns, not permitted to return back, not permitted to re-enroll. Well, now you have a picture, at least part of a picture, of some troubling information. And before you make that offer to admit, you might want to dig down further and see if there's been some kind of psych evaluation. But generally speaking, don't ask at the first blush. If you can, wait until after you've offered, but, there's always a but, right? It's a general rule and then an exception. If you do learn information that gives you cause for concern as to whether this child's going to be safe in your community, you also have an obligation to follow up on that and make that determination. So I know that's a little bit of a convoluted answer to what could have been a yes or no question, but unfortunately that's just the reality. So when a parent asks for a reasonable accommodation, that does not mean that you are obligated to provide it at the outset. You can and should assess, is it reasonable? Is it necessary to allow the student to participate? So extra time because your hand hurts? No. Extra time because you have a processing delay? Yes. And would the modification fundamentally alter the nature of the school, cause undue hardship? Emotional support animals, by the way, not a reasonable accommodation. Service animal, yes. Emotional support animal, that just, the ferret that like sits on your lap. I've seen a support ferret, an emotional support ferret. That I saw one at the airport this morning. He had a vest. He had a vest. Right? But that's not a reasonable accommodation because that's not, a service animal is trained to perform a task. An emotional support animal is just there to like make you feel better if you're getting stressed. Also a distinction. Before we move to New York State, any disability questions, any further? Okay, yes?
It's not really, it may be a little wrong.
I love off topic, let's do it.
Can you ask on an application whether the children are vaccinated?
It just gives me so much joy, the reaction from this room. Oh my God. So, well, deciding not to vaccinate is not a disability, right? Well, I might think it's a disability of certain parents, but that's for another date and time. You could ask if they're vaccinated. In New York State, you are required to consider, and I say consider, not grant, medical exemption and religious exemption based on a sincerely held genuine belief that is tied to a religion's tenets. So, whatever religion mom and dad have cooked up today is not going to cut it. So, you could ask, are the children vaccinated? Will you be asking for an exemption? You could ask that. You could get a claim for religious discrimination if you exclude on that basis. You could get a claim of disability discrimination if it is a medical exemption, an actual contradiction. But you might also want to know, am I going to be inundated with exemption requests in June? Up to you. One of those risk-benefit analyses things. Measles outbreaks are very scary. That's something you might want to know before you let this family in. Maybe you make the determination on the exemption, you condition the timing for signing the enrollment contract on the determination of the exemption, giving parents an out. You can find another school. If we don't grant your exemption, you can try to shop it to another school. Maybe you do it that way. But risk-benefit, liability exposure, but I'd also want unvaccinated kids running around. Excellent question. Excellent. New York State human rights law. So like I said, substantially broader than the federal level. Specifically applies to independent schools, by the way. This is unlike most other state human rights laws. Certainly Virginia, where I live, it like barely applies to employees. This applies to independent schools. And your protected classes are bolded. You can see quite broader than the federal level. Sexual orientation, no protection at the federal level. Gender identity or expression, no protection at the federal level. By the way, Supreme Court declined to hear 3 cases on that issue this term. Military status, not really sure how that applies to kids in schools, but we'll go with it. Marital status, also not protected at the federal level. So be aware as you're forming your questions and you're going through your interview and admissions processes that these are additional protected classes you need to be wary of. Same-sex schools, by the way, you're permitted, you're exempted. For race, this is a 2019, 1 month ago development. Race discrimination in New York now includes hairstyle. This is fascinating. If you haven't read the EEO guide or the DHR guidance that came out of this, it's really interesting. It describes how derogation of certain hairstyles really came out of the slave trade and the slave era. So if you haven't read it, I commend it to you to read. And I think we're going to see a lot more movement in this direction of state law explicitly recognizing things that were perhaps cultural characteristics, considered cultural characteristics, as included within a protected class. Federally, sex didn't include pregnancy for a very long time. I don't know a biological male that's able to get pregnant, so I don't know why it took that long, but it did. Anyway, I know I'm running up on time, but we're going to talk about vetting quickly. Why do you vet? Negligence. Just like you can have a cause of action for discrimination, failing to admit, you can also have a cause of action for admitting someone into your school who is not safe to be around other students. As a school, you have a higher duty. You're considered to be acting in loco parentis. Lawyers love Latin. I don't know why we have to throw it in everywhere, like I just did. But you are stepping, literally, it means literally stepping into the shoes of the parent and vetting, taking care of them like you would the parent. I certainly want to know about the kids my daughter's hanging out with, and just as a school, you should know who all these kids are together. What does that mean? Thoroughly vet them. How do we thoroughly vet? Lesson learned, the serial drug dealer. This kid went to one school, dealt drugs, got caught, got expelled early in the year. Shows up at another school, deals drugs, gets caught, gets expelled. Spring, shows up at yet another school. What does he do? Deals drugs, gets caught, gets expelled. How did no one know that the reason the kid was getting expelled was drug dealing? It's because no one vetted him. And no one vetted him and no one shared that information. That means, for you guys, get the educational history. Get it all. Dates of departure, reasons for departure, gaps in educational history. If a kid left one school in January and popped up at another in April, what was he doing from January to April? You're going to want to know that. Specifically inquire into disciplinary issues. Please, please, please ask. In certain circumstances, a school may not be able to tell you the reason, maybe because there is an actual settlement agreement between the parents because it was that blown up. But you can ask, is he eligible? Is she eligible? Shouldn't pick on the men. Is she eligible for re-enrollment? And if the answer is no, that's a red flag. Don't rely too much on teacher recommendations. I love teachers, I really, really do. They rarely know the full story. They have the picture of the kid in their class, but you're gonna want that information from the head of school, maybe the CFO if the CFO ended up getting involved, the counselor about the fuller picture. I love the internet. Social media and Google searches are brilliant and amazing, and you should all be doing them. You can find a ton about a person with 3 minutes and an internet connection. I can find anybody. It's honestly scaring for them, not for me, but for them. So definitely do them, and people forget themselves on the internet. They forget themselves on social media. They're behind a screen. They don't think about what they're saying, and they say whatever comes to the mind. Some lawyers, oh look, Janice is going to contradict herself again. Some lawyers say, don't do that. What if you inadvertently find out about a protected class? Put your blinders on. Stop. Maybe you'll inadvertently find out about something. But like I said, what? Almost everyone's a member of a protected class. And 2, just don't make your decision based on that. If you do find out about violent, threatening behavior, that you can consider. That you can absolutely consider. And by the way, if you're not doing the social media searches, you better believe your parents are, like me. I'm crazy. I'll find out everything. And then if you don't want them walking up into your office and saying, you admitted this kid? Look at that, he does drugs. You want to know. It's happened, by the way. Sorry, just 1 second back to special considerations for international students. Consider the difference in criminal law between the receiving country and the United States. Things that we might not care about, the royal we, the United States, might not care about, might be criminalized in the country and vice versa. If you're relying on a third party, be careful to also do your own due diligence behind them. Don't just accept blindly what they say. And then, my light primer and enrollment contract, a little teaser, if anybody wants to stay. Use your enrollment contract wisely. Don't waste it. It's a contract. It might be the only thing your parents read. So I didn't actually read my daughter's enrollment contract, full disclosure. Use it for more than just paying tuition. Build in provisions for your student-parent handbook, for behavior, for college and university reporting. What happens if mom and dad are in a divorce and mom and dad both subpoena the school? Who's going to pay for the school's legal fees? Oh, mom and dad are. Do an activity permission, release of claims. It'll make your life easier at the back end, and also consider who's signing and follow up on those signatures. So, just 3 minutes over, 4 minutes over, and that is your legal roadmap.